So, welcome. For today's CRPS Legal webinar, we have with us today Steven Akerman, who is a solicitor and the director of Barr Solicitors. As a charity, we've been working with Steven and Barr Solicitors for a number of years as a law firm on our CRPS legal panel. Barr Solicitors are a leading specialist firm of solicitors who deal uniquely with chronic pain litigation, including complex regional pain syndrome. Although they are based in Manchester, they will assist clients and have done and will do throughout England and Wales. Just a little bit about our legal panel. All the law firms who join our legal panel are very carefully chosen by the trustees and the charity in general. They all have to specialise in personal injury, clinical negligence, or generally legal claims where CRPS has been a factor. As a charity, we definitely do understand and can empathise with you how complex, complicated and overwhelming facing a legal claim can be and is. So I hope that today's webinar will give you some information and support about pursuing a claim in England and Wales. Today's webinar is entitled Understanding Your Rights, Navigating the Personal Injury Claims Process for CRPS Patients. Today, Steven will delve into the personal injury legal claims process and hopefully shed some light onto your rights when it comes to pursuing a claim for complex regional pain syndrome. Please do ask questions in the chat box, and certainly at the end, there will be an opportunity for you to ask your questions to Steven. So welcome, Steven. I believe it's over to you.
Thank you, Victoria, for that wonderful introduction. I just want to add that it's an absolute pleasure working with yourself and Burning Knights. Whilst we certainly cannot compare what we do to the completely selfless work undertaken by yourself and all those at Burning Knights, we are glad we can at least do our little part here at Barr Solicitors. The evidence speaks for itself in terms of the amazing dedication by Burning Knights and Victoria in particular, given the recognition by the Crown itself, as she has, of course, been awarded an MBE for her charitable work. Victoria is a true inspiration that no matter what the circumstances, when there is a will, there is a way, and there really is no barrier to doing something that you truly believe in. In terms of the part we play at Barr Solicitors, it is of the utmost importance that the appropriate legal representation is obtained for all sufferers of chronic pain and of CRPS in particular. Just as one goes to a pain expert to diagnose and treat CRPS, one needs to go to an appropriate solicitor who knows how to handle such claims to ensure that individuals get the compensation they require to make their lives as comfortable and accessible as possible, given their condition. Just as one can have an absolutely fantastic GP and even the best GP in the country, if one has CRPS, that GP will refer them to a pain expert, given that CRPS requires the input of a pain expert. So too, that is our role here at Barr Solicitors from a legal perspective. One of the most heart-wrenching comments I hear from clients and sufferers of CRPS is that people do not take their condition seriously. People are skeptical. People second-guess sufferers of CRPS, and it's really disheartening. Indeed, I once heard from a very intelligent individual, the founder of the firm for which I now work, Brian Barr himself, that it was once commented to him that personal injury lawyers do not really help people. The impression he was given is that personal injury lawyers simply help fuel compensation culture, and that they can even be a blight in society. We all read that in certain press reports. But Brian, however, did note that personal injury lawyers do indeed play a very important role. Someone who's involved in an accident they come up against multi-million-pound insurance companies. All that an insurance company cares about is paying as little compensation as possible. We all know that they're quick to take money, but when it comes to receiving money, a payout, it's a lot more difficult. It therefore brings a high level of satisfaction when we run a successful claim to ensure the injured party receives the level of compensation that they require. I will not say it's the compensation that they deserve, but that they require. I'm sure it could be agreed that no amount of money can replace one's health. Every client I talk to would much rather have their health than any sum of money. The funds that one receives as part of any personal injury settlement are the funds needed for the individual to lead the best quality of life possible, given their newfound condition. In the case of CRPS, this might include the funds to pay for a carer, have a stair lift, have a mobility vehicle, and the like. Of course, every case is different. CRPS, as will be discussed, affects Many different people in many different ways. However, affected, those people need and require the appropriate level of compensation to give them the best quality of life that was robbed of them as a result of any accident. With that said, what are the legal requirements to bring a successful personal injury claim? Well, there are three main elements. The first is liability. The second is causation, the injury, what injuries were caused by the accident. And the third is quantum, which means what is the value of the claim. I will, of course, discuss each of these in turn, dealing first with liability. Liability is the responsibility for the accident in order for one to be able to claim compensation. With regard to liability, sometimes in life, accidents happen and are not the fault of any particular party. However, if someone is the victim of a road traffic accident or workplace accident or even of medical negligence, then if one can establish that the other party is at fault for the accident, then they are liable for damages sustained as a result of the accident or negligence. In order to establish liability, one will have to show that the other party owed what is called a duty of care to the injured party, and that duty was breached. In the case of a road traffic accident or any workplace accident, that is relatively straightforward. Obviously, any driver of a vehicle or an employer has a duty of care to either the other road users or the employee in question. If that duty falls below the appropriate level, then that duty has been breached and compensation can be sought. Some cases are, of course, more straightforward than others. If one is involved in a road traffic accident where the other driver went into the rear of the vehicle you were driving, well, there's then a presumption that the vehicle behind is at fault, as that vehicle should have left enough space to stop in the event of an emergency. Right? We always see on the motorway, keep your distance, keep two chevrons apart. It's for that very reason is that emergencies happen. There could be something you cannot see, and one has to leave enough space to anticipate an emergency, slam on the brakes, and prevent an accident from occurring. But even if one is behind, it's not always the case that the person behind is at fault, but it's what we call a rebuttable presumption. The starting point is that the vehicle behind is at fault, but if there's evidence otherwise, then the court can take that into account, but it is very difficult to rebut that presumption. There are then, of course, other situations where it is not so clear-cut. Not every adverse result is a result of negligence, unfortunately. For example, if one is at work and slips on a wet floor, it does not necessarily mean that the employer is at fault. If they clean the floor properly and put up warning signs, it could be that whilst a very unfortunate accident occurred, the employer is not at fault. I myself have dealt with a few inquiries where that's transpired, and unfortunately, there is no claim. People can only lessen the risk to such an extent, and unfortunately, accidents do happen. Again, everything will depend on the specific facts, and sometimes, even if there are warning signs, there could still be at fault. There could still be fault on the part of the employer. So it is always important to seek legal advice. I cannot stress enough that every individual case depends on the specific facts. Two cases may seem similar, but may actually have very different outcomes. Medical negligence claims in particular are notoriously difficult. Just because someone receives poor service, and unfortunately it does happen on occasion, it does not mean that there was specifically any negligence. There's a very high bar to establish that a doctor in a particular case was negligent. The likely reason is that there are a lot of unknowns with regard to medical treatment. There could be a variety of medical opinion on how to carry out a specific treatment. And doctors do have to be able to conduct their profession without an easy lawsuit hanging over their heads. But at the same time, it is a balancing act because they have to take responsibility for their action. So with that balancing act, it can be difficult to establish negligence. For example, there are always risks associated with any sort of surgery. Once people are put under general anesthetic and go under the knife, as they say, there are always risks. Therefore, just because a complication occurred does not mean that there was any poor service at all on behalf of the surgeon. Everything could have been carried out to the highest possible standard, and sometimes, unfortunately, complications do arise. Chronic pain is a real risk of any surgery. It is a very unfortunate complication, but it can occur, and even if everything is done right, the doctor cannot always be criticized. Of course, there are some cases where it's clear-cut. For example, if a surgeon did not take the appropriate risk factors into account before undertaking the procedure and a complication ensued, the surgeon is almost certainly negligent. In such a situation, because the surgery should have been never undertaken, any complication is the fault of the surgeon. And in fact, compensation can actually even be sought for the surgery itself, because that is an injury, so to speak, that should have never occurred if the surgery itself should have never been undertaken. Just to give you an example, I recently had a client who had to undergo multiple spinal surgeries, and complications did in fact occur. And there was actually a bit of a leak of spinal fluid following one of the surgeries. However, I did go to an appropriate spinal surgeon to ask if there was any negligence, but the opinion was that in that scenario, there was no negligence. Everything was done as best as possible, and maybe things could have been a little bit better, but second guessing does not always mean that there was negligence. And unfortunately, we were unable to establish that there was medical negligence in this scenario, but at least the individual in question doesn't have to ask themselves, what if I would have proceeded with a claim. That person can now know at least that it's been investigated and can move on as best as possible. So that's liability. We have to first establish that someone was indeed at fault for the accident. So if we establish that, then we come on to causation. Right. Once liability has been established, there needs to be an assessment of the injuries caused as a result of the accident or negligence, depending on what the case may be. In legal terms, one has to ask what would have occurred but for the accident. If something would have occurred in any event, then compensation cannot be claimed. One can only claim compensation for what was caused by the accident. This is actually a very important point when there is relatively light trauma. If there is a very minor accident in terms of maybe a sprained ankle or sprained arm, which can be painful, but then the client goes on to develop CRPS, which can happen, and which I've seen, the question can be asked in the sense that perhaps this individual would have developed CRPS in any event. Everyone has some sort of trauma during their lives, stubbing a toe, banging a hand, twisting a ligament. They are quite common occurrences. Therefore, what the defendant can argue in such a case is that such individuals would have developed CRPS in any event, and when some non-accident related trauma would have occurred in the normal course of one's life, they would have developed CRPS. So, but for the accident, they would have still developed CRPS. In that case, they can try to get out of claiming compensation for the injury. It's not always straightforward, but it is an argument that I have seen. Also, in less severe cases of CRPS, the diagnosis itself can be brought into question. Some of the criteria, as I'm sure many of you know, for diagnosing CRPS are temperature changes, excess or less hair growth, mottled skin, and skin color changes, to name a few. However, in every individual, this can vary to different degrees. On some days, some of these symptoms cannot be present at all. Therefore, when they're examined by medical experts in the personal injury claim, because we do need experts to comment on the condition and whether it was caused by the accident, there's a question as to whether they are suffering from CRPS at all. This is despite the fact that the condition can be diagnosed by treating clinicians. However, because these individuals do not have severe cases of CRPS, the whole diagnosis is brought into question. I've seen this many, many times. Treating doctors are certain it's CRPS, and medical legal doctors say otherwise. And it can be very hard. It can be very difficult to deal with. I cannot even imagine what this does to the individual who is simply struggling with a newfound condition, and then the whole condition is questioned at its core. I would also like to point out that even if the medical legal expert disagrees with the treating clinician as to what the condition is, it doesn't mean compensation will necessarily be denied. If this newfound condition, whatever the case may be, which I'll discuss in a moment, if that is linked to the accident, then it doesn't really matter what it is. If it was caused by the accident, if it's causing losses, which we'll discuss later on, then you can claim compensation. Obviously, the diagnosis is important because we need to know how to treat the condition. But as far as a personal injury claim goes, as long as there is a condition that has been diagnosed and linked to the accident, then compensation can be sought, even if it's not the condition that maybe you thought you had in the beginning. Indeed, an alternative diagnosis is very frequently given in these personal injury claims and is what is called a somatoform disorder, which many of you may already be familiar with. This is a psychiatric disorder which explains the claim from a non-organic psychological or psychiatric perspective. Whilst I always explain to claimants that this does not mean that the pain is any less real, it just means that there's a psychiatric or psychological cause as opposed to a physical cause. And it does not mean that the pain is all in their head, or that it's manufactured, or that it's not real. It's just as real as stubbing a toe. It's just as real as breaking a bone. It's just a different source of the pain as opposed to a physical source. But it's not any less legitimate than any other sort of pain. If it is a psychiatric disorder, then experts will delve into a person's past and determine whether they had any trauma, whether it could be abuse, previous bouts of depression, PTSD from previous accidents, or any psychological trauma that predated the accident. If that is the case, then it's a very convenient excuse for defendants to simply say that the condition was not caused by the accident, but is really a sort of a reimagination, so to speak, or a presentation of the pre-accident symptoms or trauma coming to the fore now, either causing the condition now, or they can argue that but for the accident, the trauma would have manifested itself at some point in the future, and therefore they're not responsible for the person's current inability either to work or need for care, because they would have had these complications at some point in the future in any event. Indeed, even in severe cases of CRPS, so we were just talking about less severe, but even in severe cases of CRPS, where the diagnosis is incontrovertible because of the severe symptoms of swelling, color changes, and even in some cases amputation, the defendant still uses somatoform disorder to try to get out of accepting full responsibility. What they will try to argue is that there is CRPS with an overlay of another disorder, whether it be somatoform or the claimant's pre-accident trauma, that's partly responsible for the pain. The defendant can therefore try to argue that the accident is not wholly responsible for the claimant's current condition and disability, and try to reduce damages accordingly. What this really underscores is that in order to successfully deal with litigation involving CRPS, one has to have a great and deep understanding as to the level of skepticism that would be put forward against claimants in such claims. Whatever skepticism CRPS sufferers feel on a day-to-day basis, it is amplified infinitely when it comes to litigation, and they're seeking financial compensation. Unfortunately, every litigant is tarred with the same brush, and that they're just in it for the money. Horrible, and in many cases disgusting, but unfortunately, that is the way insurance companies sometimes will approach these claims. It therefore takes solicitors, such as Barr Solicitors, who have years of experience dealing with defendants on such a basis. In fact, dealing with the defendants is the easy part, because we know all the tactics, and we know how claims can be undermined or attempts to discredit the claim. We have a database of experts who understand the condition and will give claimants a fair examination and opinion. Of course, it's not for us to determine whether any particular condition was caused by the accident or not, but what we do ensure is that we send our clients to well-balanced experts who understand the condition and who can offer a fair, impartial opinion. I always explain to clients that we cannot guarantee a result. We cannot guarantee a supportive opinion, but we can guarantee that an expert will cut through all the noise and unfair comments. The expert will understand the condition. The expert will be able to offer a well-balanced opinion, and the claimant can be satisfied that they got a fair hearing, that it was dealt with properly. So we've dealt with liability, we've dealt with causation, and now we have to, so assuming we get over those two hurdles, we have liability, we found a responsible party, we have supportive medical evidence. We then have to deal with quantum, the value of the claim. How do we value a claim? It should be noted that these claims can run into 6 or 7 figures. And even though you will get your own supportive medical evidence, defendants, because these are such high value claims, will obtain their own medical evidence. So there could be a divergence of opinion. You'll have your evidence stating that it's a 6-figure or 6-7-figure claim, and very frequently, because of the arguments we discussed, the defendant's evidence will say this is a very low value claim, 5 or even 4 figures. I have seen it many times. So when we value the case, we'll value it on the supportive medical evidence, but it's worth bearing in mind that there may be another set of evidence valuing it at a much lower amount. So this is a very difficult area, and people can struggle with it, and understandably so. On our website, we have testimonials of people who have won hundreds of thousands of pounds, or even sums in excess of £1 million. The basic facts are written, and I have inquiries or clients ask, well, my case sounds very similar to that case, so why is my case valued at so much lower? As with everything in personal injury claims, it all depends on the specific set of facts of each particular case. There is, of course, compensation for the injury itself, but in England and Wales, this is a very paltry amount for chronic pain. In very severe cases, it can be limited to £50,000 or £60,000. I know that sounds incredibly low, but those are the guidelines set by the government. There is some leeway, but it's pretty fixed. There's very little we can do about that. Where the real value to a claim depends on the person's personal circumstances in respect of loss of earnings, care, and possibly accommodation, which I will discuss in turn. One of the most difficult aspects in this regard is when people are already disabled due to other issues that are not accident related. For example, if someone already has poor mobility or is unable to walk due to a condition such as severe arthritis or different chronic pain condition or any sort of disability, then even if CRPS was caused by the accident, one cannot claim damages for loss of earnings and care because those losses were caused by non-accident related factors. Of course, there's a very big gray area. There are many people who are working part-time and who need minimal care, but then the accident occurs and increases the care mobility, and inability to work. In that situation, one can claim for the additional loss as a result of the accident, such as CRPS if that was caused by the accident. For example, if someone has poor mobility and then develops CRPS in the leg, which means they may even now need to be wheelchair bound, then of course their care needs will increase significantly. That increase can be claimed as a result of the accident and as compensation. Additionally, if someone is working a job that requires both their hands, such as someone working in manufacturing, and then they go on to develop CRPS in the arm, meaning they have to retrain or even take a lower paid job, then the resulting loss of earnings can be claimed as a result of the accident. Put another way, if someone is working 3 days a week before the accident because they can't work full-time because of some other disability, and then they develop CRPS and cannot work at all, then they can of course claim for the reduction of 3 days to 0 days. But those other 2 days of the working week, 5 days, the additional 2 days cannot be claimed because that has nothing to do with the accident, even though they cannot now work at all. Similarly, if someone received 5 hours of care before the accident and now receives 10 hours of care, those additional 5 hours can be claimed as a result of the accident. Again, the 5 hours relate to pre-existing disability. Those can't be claimed, not result of the accident. Now the person needs an additional 5 hours of care, and those additional, that balance of 5 hours can be claimed as a result of the accident, assuming, of course, there is supportive medical evidence. Additionally, if one has to change accommodation as a result of the accident, this can be claimed as well. For example, if someone was able to manage previously in multi-story accommodation, but now needs a bungalow, the compensation can be sought in order to obtain financial aid in fitting out single-story accommodation. If one now needs a wheelchair and doors have to be widened, ramps installed, and specialist vehicles obtained, that can be claimed as well. Again, it all depends on the specific facts and the severity of the injury. Now it really can be seen how the value can vary greatly for the same injury. Two people can have exactly the same injury in terms of CRPS in a limb, very severe, but if one person was earning, say, £50,000 before the accident, and the other person was earning £20,000 before the accident, then the yearly loss of earnings claim will differ greatly, and this difference grows substantially if one multiplies that by the number of working years left in one's life. Additionally, age is a significant factor. Someone who is 60 will have far less loss of earnings, even if they were earning significant sums before the accident, as opposed to someone who's only 20. Someone who's 60 maybe has 5 to 10 years of working left before they take their pension or retire, but someone who's 20 obviously has multiple decades. That will increase a claim significantly. So someone who's 20, earning £20,000 a year, can very likely have a far larger loss of earnings claim than someone who is 60 or 65 earning £60,000 a year, because someone in 20 will be claiming probably 40 to 50 years of loss of earnings, where the person earning £50,000 at 60 will maybe 5 or 10 years. So when one does the math, we can already see how the value of the claim can vary greatly for two seeming similar accidents. And the same goes with regard to care as well. Someone who did not need any care before the accident, but now needs significant care, will have a far higher care claim than someone who already required care before the accident. If you multiply this over many, many years, there can be a very big difference in the value of the claims by hundreds of thousands of pounds, even if both injuries sound very alike. Age, of course, affects care as well. Obviously, the older person is, the less amount of care has to be claimed for the future. As opposed to someone who's 20 years old, well, there'll be many more years of care to claim, just as we discussed with loss of earnings. This is also where the difficulty in proving what was caused by the accident really comes to the forefront. Someone who has an existing disability may deteriorate over time and may need increased care and may have to stop working regardless of the accident. Many conditions are progressive. They simply get worse as one gets older or over time. We all age. Therefore, defendants will very frequently make arguments that because the person was already struggling before the accident, the condition would have progressed, say, within 2, 5, 10 years, whatever the case may be. And therefore, the damages should be limited. What we will try to do with expert opinion is to show that no, this person was capable, they mastered the disability and were doing really well before the accident. We will put forward that the accident caused a permanent increase in the disability that would not have occurred before the accident. But it's crucial that the right questions and the right experts are approached, who understand the condition and can give a fair consideration of all the facts. Just to put the loss of earnings example in terms of more specific figures, using the example of a 20-year-old earning £20,000 a year, that could, 20 years loss of earnings at £20,000 per year, that amounts to £400,000 of loss of earnings. Now, it's not exactly £400,000 because there are complicated legal calculations, but for today, it can be said simply that it's a £400,000 loss of earnings claim. But if the defendant will limit that to 5 years because that person would have struggled within 5 years due to a pre-existing condition, then £20,000 times 5 years is only £100,000, a difference of £300,000. That is with regard to loss of earnings, but if you take that into account for care, accommodation, and all the other aspects of the claim, then that can really, really reduce the claim. Just so simply, one argument can reduce the claim by hundreds and hundreds of thousands of pounds. Another favorite argument of the defendants is to say that there will be a favorable prognosis. In other words, the individual will make a miraculous recovery and be able to work and not need any care. I know it sounds almost comical. Of course, some improvement of the treatment is possible, but the assumptions made on the likely recovery can sometimes be astounding. But it really is no laughing matter. People need compensation. If they can never work again, they have to make sure that they get the appropriate compensation. If for loss of earnings, if they need care, they have to pay for a carer. If they need single-story accommodation, they have to pay for accommodation. So whether someone will have a favorable prognosis or not is really an important point that needs to be considered in great detail. If such claims are believed, then that will limit the claim significantly. And in almost all cases, not in all cases, but in the majority of cases, there's one bite at the cherry. Any settlement is in full and final. Again, there are exceptions to the rule, but it is really important that we get it right. Because to go back at a later date can be quite difficult. That is why expert legal help is really necessary in these claims. Barr Solicitors, we understand how to differentiate between pre-existing disabilities and post-accident disabilities. We understand the appropriate experts who need to be instructed and the appropriate questions to ask. We understand how to interpret the pre-accident medical records and to ensure that the defendant's arguments are undermined and that one receives compensation caused as a result of the accident. Again, I must stress that we cannot guarantee a result. What we can guarantee is that we know how to review records and go to experts who will give them a fair, impartial hearing or consideration of their condition. That is their job. Their job is not to, their duties to the court to be impartial, not to favor us, not to favor you, not to favor the defendant, but to be impartial. And given the level of skepticism surrounding chronic pain, we make sure that the appropriate experts who will give matters proper consideration are instructed. So those are the three elements of a personal injury claim: liability, who is responsible if there is anyone, causation, what were the injuries resulting from the accident, and then quantum. But although I've discussed the three main elements of the claim, there is this important subcategory that needs to be discussed. That is the frequent allegations of dishonesty and that one is faking or manufacturing their symptoms for financial gain. As is almost always the case, defendant insurance companies approach every single personal injury claim with skepticism. They think everyone is putting it on in order to claim compensation. I know that sounds horrible, but they're only interested, mostly interested in reducing the amount of compensation they have to pay. Whilst easier said than done, there is no need to take it personally. It is really hurtful, but they don't really approach it as there's a person on the other side. They just run it as there's a number and they have to reduce that number as low as possible. And we all know that a sufferer of CRPS can be suffering from a variety of symptoms, not only pain. These can include sensitivity of touch, poor sleep, cognitive difficulties, all because of the pain. Therefore, the effect of the CRPS is very much more than a simple pain condition in the affected limb. It has a much more wide-ranging effect on the person's abilities. Secondly, sufferers of chronic pain of a chronic pain condition, and CRPS in particular, have good days and bad days. On good days, an individual may look like someone who does not suffer much from any medical condition, but of course that is dependent on how severe the CRPS is, as it could have a wide-ranging effect. Someone who has mobility issues will always have those issues, but even in such a case, sometimes people can get around without a wheelchair. They can get around on crutches, but on another day, they can't weight bear at all, and they'll have to use a wheelchair. It's not a contradiction. It's just part and parcel of the nature of the condition. Therefore, people who do not understand the condition and will see these individuals on one day weight bearing to some degree and the other day in a wheelchair, it does breed a little level of unfair skepticism, and this can lead people to believe there's really nothing wrong with the individual, or they're exaggerating their symptoms. So real understanding of the condition is necessary. Thirdly, given that there are varying degrees of pain and disability associated with CRPS, some individuals can work full-time, while others part-time, and others not at all. Again, this will lead to confusion about CRPS, because some people say, well, I saw this other person who was able to work, why can't you work? So again, an understanding the condition and how it affects different people in different ways is necessary. But when it comes to chronic pain litigation, these points can be used against claimants in an unfair fashion. Very frequently, because of the level of disability is based on individual self-reporting, claimants and personal injury claims are put under covert surveillance to see if they're telling the truth. This makes it even all the more difficult for sufferers of chronic pain. Not only do they have to deal with real-world skepticism, but now they may be put under surveillance in an attempt to undermine their claim. I do my best, as I've said, to explain to individuals that it's not personal. The insurance company are just doing what they do in order to make sure there's an honest client, and we have to do what we do in order to advise clients appropriately. Usually, when there's a high level of disability, surveillance is very much limited. After all, if the individual cannot walk or has difficulty walking, that will show up on the surveillance. I can actually validate the claim. I have had many claims where the surveillance is disclosed, and we look at it and we say, well, that's exactly what that person said. That's why a very good understanding of the condition is necessary, so we can make sure that all aspects of the condition are taken into account. So if there is surveillance, we welcome the surveillance, because having surveillance video footage confirming your condition is much better than putting it in writing in a text. Seeing it in a video is much more, makes it much more understandable as the level of disability and ability to claim compensation. So that's really what the problem comes in less severe cases of CRPS, when the disability is far less pronounced. For example, let's say a person has CRPS in their arm as opposed to the leg. The individual can still have all the worries about sudden spikes in pain, difficulty sleeping, or simply being very protective of the affected arm, not to knock it in any way that can cause a flare-up. Even if the CRPS is not very severe, I have clients explain to me all the time that they have a flare-up. If they have the flare-up, the pain can be overwhelming, causing them to have to stay in bed for days on end. However, when they are not suffering from severe bouts of pain, they can be seen to lead a relatively normal life. They can go to work, go shopping. This is then used if there is surveillance, and if the condition is not considered properly by the solicitor against them. Why are they going shopping if they're saying they're disabled? Why can they not work? Why do they need help around the house with cooking and cleaning? But as I'm sure all of you can appreciate, this is not always the case. It can be a bit disingenuous. So it's perfectly understandable that there are good days and bad days, and that's what has to be taken into account. The advice I always hear, which is given to my clients by the treating doctors, is that they should not give up. Doing nothing is terrible, and it can actually make the condition worse. So they should do as much as possible, but they have to pace themselves. So there's a balancing act, right? Of course, everyone has to follow what their own doctor says, but that's what I hear very much from clients, is that they go out, they try to go for walks, walk the dog or whatever the case may be, go to the park, because they have to be as active as they are able to be. But again, that is part of the condition, that's part of the treatment. So if they're having a particularly good day, claimants may try to go shopping. They may try to use the affected limb as much as possible, but it's not that it's inconsistent with their condition. It's actually consistent with their condition and the medical advice that they are given. Therefore, this is where expert opinion and understanding of the condition is necessary. We at Barr Solicitors take extreme care in dealing with such allegations. In fact, dealing with the defendants is the easy part, because as I've said, we know how they run their claims. We provide a caring and understanding ear to claimants, and we want to help them feel comfortable in going through litigation. We want to make them aware of the fact that we can deal with and shoulder the burden of unfair comments being leveled at them. We can filter it all, and all they have to do is worry about going to the doctors and getting the treatment they require to get better. Whilst in most cases, CRPS is incurable, there are treatments out there that can help one manage their condition. And what we at Barr Solicitors want for our clients is that they focus on treatment and we focus on litigation. Let us focus on the skepticism and unfair comments. All you have to focus on is getting better. So those are the elements of the personal injury claim. But I know sometimes people ask, what about negotiation? How does it work? Do I have to go to trial? So really negotiation starts as soon as the claim starts. As soon as defendants get a sniff of a high value claim, even before medical evidence, we very frequently get offers of £50,000. While in isolation, this is a lot of money, £50,000. Obviously, for someone who cannot work and needs many hours of care a day, it's a paltry amount. However, insurance companies hope to buy off the claim early before an even higher value is established and significant legal fees have been incurred. However, whilst we certainly cannot guarantee how things will turn out, in order to receive a significant amount of damages, one needs to obtain medical evidence. So we can't guarantee how things will pan out. It can be hard to hold to one's nerve. Will there be surveillance? Will the other side's medical opinion be really unhelpful, forcing you to take a lower offer at a later date? All very real possibilities. But we try to put our clients' mind at ease and advise them that things need to be investigated. And when we believe in a case, we fight it to the end. Most cases settle amicably via negotiation, but if pushed to trial and we assess your claim as having good prospects, we will take that risk with you, as we almost always act on a no-win, no-fee basis. We do not get paid if you are not successful. Just because the other side's evidence appears unhelpful does not mean it will be persuasive, and it's our job to fight your corner and obtain the best possible award once you are on receipt of medical evidence. But of course, you don't have to take my word for it. You can have a look on our website. We have a lot of written testimonials. We have even video testimonials. We do get results. Recently, I had a case where the defendants went very, very hard at one of my clients. They were saying the person was very, very dishonest. If they would have made offers before it went to trial, we would have settled low six figures. In the end, they weren't interested. It went to trial. It went very, very bad for them, for the other side, that is, and we were able to get a settlement in the mid to high six figures. Yeah, so it's something that, you know, every case is assessed on its facts, and it's something that needs to be taken into account on each individual set of facts, medical records, medical experts, and if any allegations of dishonesty, those need to be considered very, very carefully. Another question we get asked very frequently about changing solicitors. It's not a problem. It's very easy. You know, when claims start out, people aren't aware that it will be a chronic pain case because they don't have chronic pain straight away. It can take a few months to develop. And so you can, of course, come to us at a later date once you realize that you need expert opinion. We've recently had 2 people come to us, I think in the last 7 to 10 days, who called us a few years ago and they didn't want to come over, which is, of course, their prerogative. It's their claim. They could do as they please. But unfortunately, things didn't go as planned for them, and they came back to us now asking us to take over the claim, but it was too far developed, too far along, and we weren't able to help them. The earlier that we are instructed, the earlier we can help. So yeah, you can go on our website, see all the testimonials and all the contact information, and if we can help you, we'll be happy to do so. I hope that was very informative, and I'm happy to go back to Victoria to put any questions towards me, and I'll see if I can answer any of them.
Thank you, Stephen. Yes, extremely informative, and yes, we do have some questions for you. The first one is from Rachel, and she said, does which part of the country you live in have an effect on the money received from a claim? Thank you.
Usually not, but it can in an indirect way. If someone's living in London or in the South, where generally people get paid more, so then their salary will be more, so therefore the loss of earnings will be more. Or if carers are more expensive in London, because everything's more expensive in London, that's just the way it is. So then you're allowed to claim for higher care costs or higher accommodation. If you need to buy a house, then obviously housing in London in the South is very, very expensive. But obviously if someone lives in a less expensive part of the country, they can't claim London rates. So it doesn't really matter where you live, but indirectly it can. If things just cost more where you are, then you can claim that additional cost, but you can't claim the additional cost if you're living obviously somewhere where it's cheaper, not as expensive.
Does that answer your question?
Yeah, great.
Another question, can it make the claim harder if you already have pre-existing conditions, or does it depend on what they are? And then there's a sub-question to that. So
it can certainly make it harder. You know, as I've said, if someone has a pre-existing condition and they're already disabled, then did the accident really cause the current disability? Again, it very much depends on the facts, but it's not a bar. It doesn't prevent you from bringing a claim. Definitely seek expert legal advice. We have plenty of clients who have pre-existing conditions, and the accident makes it worse. And if that worsening is a result of the accident, you can claim compensation. So it can make it trickier. Certainly it can under certain circumstances, but it doesn't prevent you from bringing a claim if the evidence is supportive that the worsening was caused by the accident. Then it makes no difference whether it's pre-existing or not.
okay, there is a sub-question to that, and
Yeah.
it says, would medical evidence be helpful as well from the hospital? And
yeah, I can see on the side. Yeah, so also under that says from hospital and GP. So we will of course obtain all your medical records from birth, really. You know, you went to an osteopath, we'll get those. You went to acupuncture, we'll get those. Physiotherapy, pain experts, pain clinic, whatever the case may be, we'll get it all. And then that is important because we can't comment, we can't consider the extent of any accident-related injury without knowing your previous health and treatments that you've had. And then we'll send them to the medical experts who will then comment on, in the light of an interview with you, where you get to say what happened, the accident, and viewing all your medical records, what exactly did this accident do to you? And if it comes back that there is a helpful report, then based on what the expert says, then we can look at claiming losses as a result of that. But yes, medical evidence is necessary in every case, and medical records are necessary in every single case. You can't bring a claim without dealing with those two.
okay, thank you. Another question, what if my CRPS changes or gets worse over time? I presume that's post compensation.
Right. So as I mentioned earlier, most cases, not all, but most cases, it's full and final. You get one bite at the cherry. Once it settles and things get worse, then you can't go back. There are exceptions to the rule. It will depend on the facts, but that's why prognosis is so important. If the doctor says that this condition will get worse after 5 years, then we build that into the compensation, that, you know, you claim compensation or care or loss of earnings up until for 5 years. And then if the person then has to retire early, then that increases loss of earnings claim. If they need extra care, then that increases the care claim from 5 years in the future. So that's why prognosis is really, really important. Treatment's really, really important. We have to ask these questions before settlement, because if not, then you can go back to get compensation at a later date. I should also point out that the flip side, the reverse, is true as well. If the experts all say that this person's never going to get better, and then they have a recovery, which can happen, you don't have to give back the compensation because it wasn't obtained under false pretenses. We all followed the medical evidence, and doctors aren't prophets, right? Everyone does their best, but things happen that, you know, they're just giving their opinion on what's likely to occur. Likely doesn't mean it's for sure going to occur. So it's not a contradiction for a doctor to say one thing and then something else to happen, right? They can't say with certainty what's going to happen. So all we can do is get the evidence and settle on that basis. And what happens afterwards, for good or for bad, the person does have to deal with.
Thank you. You mentioned surveillance earlier.
Mm-hmm.
We do receive a lot of comments about surveillance, and clients are worried about what defendants see or what comes across. How do claimants deal, when the people with CRPS deal with surveillance?
Yeah, so I should point out that even though it's very uncomfortable and you know, people probably think, oh, this car's following me, it's all normal. But they're not doing anything illegal. If someone is in public, they have no expectation of privacy. They're allowed to film somebody in public. Obviously, if they put things in your house, that's criminal. They can't do something like that. But if you're just out in a shopping center, in the town center or whatever, then they're not doing anything wrong. That's why you really need to go to specialist solicitors, because we will make sure that everything is properly taken into account, that if that surveillance comes, we can deal with it. That we always assume on every case there will be surveillance. We assume that, we just assume from the get-go there will be surveillance. And if they don't give us surveillance, that's probably because we did a good enough job that it didn't help them, so therefore they just buried it. But we always assume chronic pain, surveillance, they go hand in hand. And you need to go to a solicitor who will prepare you for that. And, you know, our job is to foresee problems and to play devil's advocate and say, you know, not just say, you know, it's very easy to say, yeah, things will be great, we're going to get you lots of compensation, supportive medical evidence. No, we have to look at the record and say, well, this could be a problem in your records. But let's deal with it. You know, we try to offer solutions, but burying your head in the sand is not going to help you. It'll actually be counterproductive, because fixing a problem after it develops is much harder than fixing a problem, you know, in anticipation of it developing. So we get that. We get the records, review them, and we try to foresee problems that we think will come up on the case, so we can deal with it properly. That when it comes up, it's not really a problem. We've dealt with it, and we can just, you know, carry on.
Thank you. Another question. I had my accident abroad, but it was due to negligence from the campsite I was staying in. The firm is a British company. Will my claim be harder to fight? I have evidence from the holiday rep that the accident was their fault.
Right. So obviously, foreign accidents not something we can deal with. We're only licensed to deal with England and Wales. Even Scotland and Northern Ireland are considered foreign in this context. They have separate legal jurisdictions, so we couldn't even deal with claims originating there. I mean, if you live there, that's fine. I've had clients live in Scotland. I've had clients live in Australia or even Thailand once. But the accidents happened. There was someone at fault in England, so it doesn't matter where you live. It matters where the fault is. And even if the accident happened abroad, that could theoretically be brought in the English courts, and we could theoretically act for that person. But it really depends on the facts. Accident abroad, it is possible that the claim can be brought here, but without having any more detail, I couldn't really say. You can email us, advice@brianbarr.co.uk with some details, and someone will be in touch. But it is possible. All I can say, that's all I can say really, is that it's possible. More than that, without a specific set of facts, I couldn't really say.
Thank you. Another question's come in. My CRPS started in my right ankle stroke foot. After 3.5 years, it is all over my lower body and seems to be spreading. Can CRPS spreading help my claim win? Thank you very much.
So the first thing I would say is make sure you go to the doctor. I'm sure you are, but with anything, you know, early treatment is the most important thing. In terms of the claim, if it won't necessarily make it easier or more difficult. If we'll get medical evidence, if the spreading is a result of the CRPS, which was as a result of an accident, then you can claim compensation. If it spread after you settled, and there was, you know, no reason to think it would have spread, and then these things just do happen, then it's probably too late to get compensation. But again, a lot will depend on what was known at the time of settlement and what the experts say. But just because it's spreading doesn't really stop you from claiming compensation. It's absolutely still possible to do. That's not a problem at all. You just need to look at the medical evidence and ask the experts to consider it.
Thank you. At the moment, I don't have any other questions.
Okay.
Does anybody else have any questions for Steven? Feel free to unmute or no? Okay. Then in that case, I believe, thank you very much is in order to Steven and to Brian Barr for their continued support as well as for today. Steven, thank you very much once again.
Thank you for having me.
I've posted in the group chat your web link to Brian
Yes,
Barr.
thank you.
So if anybody does have any questions, I'm sure they can always follow up with you post this event.
Yeah, fantastic.
Great. Thank you very much to everyone, and have a lovely day. Take care.
You too. Oh, bye-bye.
Bye, everyone.